Oops.
Welcome, everyone, to the University of New Mexico Law and Mental Health Series, weekly discussions of practice and science featuring experts in behavioral health and the law. This series is run by the Division of Forensic Behavioral Sciences of the University of New Mexico's Department of Psychiatry and Behavioral Sciences in support with the New Mexico Behavioral Health Services Division. I'm Cassie Brown, Research Assistant Professor in the Division of Forensic Behavioral Sciences here at UNM. For our talk today, please ask questions in the Q&A, not the chat box, anytime you feel comfortable, but just know we will not get to them until the end. Also, we always try our best to get to as many of your questions as possible, so please forgive us if we cannot get to yours. If you're pursuing CMEs, the sign-in sheet will be in the chat shortly. In the last 5 minutes, a link will be posted for APA continuing education credits. You have to save your certificate after you've completed the survey because we don't keep copies of that. The recording for this week's talk should be available on our YouTube page later this week, and the PowerPoint slides will also be accessible for people registered for the series later this week as well. As a heads up for next week's talk in the series, we have Dr. Lenore Walker discussing APA professional practice guidelines for working with trauma survivors in clinical and forensic settings. But let's get back to this week. I'd like to introduce you to today's speaker, who will be discussing the importance and challenges of focusing on relevant data in forensic evaluations, Anthony Perillo. Dr. Anthony Perillo is the longtime moderator of this Law and Mental Health series and is an associate professor and training director of the forensic psychology in the University of New Mexico School of Medicine. He received his PhD in clinical psychology from the City University of New York's Graduate Center at John Jay College in 2014. He is a licensed psychologist, has conducted evaluations at the private practice, local, county, and federal levels. Dr. Perillo has received several honors from the American Psychology Law Society, including a first place dissertation award for his research on risk assessment of sexually abusive clergy, and the Early Career Teaching and Mentoring Award for his work with forensic trainees. Dr. Perillo's ongoing research focuses on factors that influence clinical judgment in forensic evaluations. As co-PI on a project funded by the National Science Foundation, he recently completed a project with Dr. Jen Perillo, examining cognitive and legal factors that lead to biased forensic evaluations. Dr. Perillo also supports practices to make forensic research more transparent, accessible, and trustworthy. And his paper on open science practice with Melanie Fessinger, Brad McAuliffe, and Jen Perillo is in the recent Oxford Handbook of Psychology and Law. Dr. Perillo, on behalf of UNM, we're excited to have you join our series and thankful for you to be sharing your expertise with us today. I'm now going to turn it over to you.
All right, thanks so much, Cassie, Dr. Brown. Thrilled to have you staying with us. As she said, research assistant professor, was a postdoctoral fellow here last year. We're thrilled to have her staying on the team. So a lot of my work outside of my training and doing clinical work has been in clinical judgment in forensic settings. And so something that's been near and dear to me is thinking about basically how we can continue to think about the processes that we use in forensic evaluations so that we can properly reflect on what we do and consider any ways that we can improve practice for ourselves or for the field going forward. So I wanted to, before I get started, thank Dr. Jennifer Cox and her student Christian Stevens at the University of Alabama, who've had some helpful discussions with me on conversation and the literature related to task relevance. As a spoiler for this, a lot of what we're talking about, we're focusing on some forensic science data, partly because we haven't really examined what is considered relevant or not across different forensic psychology questions from a survey or an empirical perspective. And we're kind of having to look at a best of what we got in adjacent categories here. I also want to thank Jeff Kukuka for the research backstory that I'll be sharing fairly early on today about some of the drama around forensic pathology decision-making and how irrelevant information can potentially affect our decision-making. So I have no financial stake in this talk, just a professional one. I have a stake in the idea that our practices should be based in the best practices that we have available to us. The best practices available to us are going to be guided by our norms, as well as the understanding that we have about what things can lead us astray. So what I wanted to start with here is a general poll with a scenario here. I'm going to give you 5 questions here. The poll is going to give you all those questions simultaneously. They're going to look very similar, except for the 4th and final one. But think about if you were court ordered to do a competency evaluation and you knew that this was a second opinion evaluation. You're not the first person to have done this competency evaluation. Initially, the defense has requested one. This evaluation, the first evaluation was done about 5 months ago. You're now being asked to again evaluate this person. And before you've done anything, you have access to the initial report that was done 5 months before you are going to evaluate a defendant's competency to proceed. So one question would be just point blank, would you look at that first opinion? The next thing to consider is, do you think that that first opinion that happened 5 months ago is relevant to your evaluation of that person's competency now? Regardless of whether you think it's relevant or not, do you think that first opinion is important to you doing your evaluation? Do you think that that first opinion could bias your own evaluation, knowing what the other person's opinion was? And then the slightly different question here is, if you did choose to look at that first opinion, when would you look at it? Would you look at it before even interviewing the defendant yourself, when you have all that info available to you? Would you first talk to the defendant and then look at it before you start making an opinion yourself? Would you do your own evaluation and make your own opinion and then say tentatively, all right, this is where I'm leaning right now. Let me look at this now and see if this other opinion changes my mind or if I need to ask additional questions? Or on the other extreme, would you only look at that other opinion after you've done your evaluation and decided what you're going to do? So Alex, if you could throw out that poll, it's going to ask these 5 different questions here, and we can hear from our audience what they would do. And we'll, of course, give this a little bit of time. We'll see what to say. I don't expect necessarily a lot of variance on some of the questions, but we'll see how some of the other ones play with each other. All right, Alex, just a couple more seconds, and I think we could close this up. Okay, so the results I'm seeing here, we have the large consensus among attendees is that they would look at this evaluation, that they do consider it relevant. The majority, but less so, would consider it important to the evaluation. And you can see this disconnect or this potential conflict as we do this evaluation, where we see the majority of people here are saying, yes, knowing that first opinion not only is relevant, but highly important. but it can also bias me. And so we need to consider here the idea that the information that we're using, it's vital to us, but something that's relevant, something that's important, isn't necessarily in and of itself purely objective or unbiasing. That there's a give and take here of looking at information that will help us, but on the flip side, could also lead us astray. Now, in terms of when we would look at it, a lot of people, the most common answer here is that they would look at it first before they conducted their own evaluation. And there are a lot of logistic considerations for why that might be a desirable thing. Other people have the most other common response here is after I've made a preliminary opinion. So doing my own evaluation and then looking at the other perspective here. There are gives and takes here, but there's clearly no consensus here of when to look at that report. But I do like that the audience is acknowledging basically there's this give and take here of relevance versus bias. And something could be highly relevant and important to our evaluation, but could still nonetheless be biasing and impact our evaluations. Now, I want to talk a little bit here about a forensic pathology study of 2021 that was highly controversial in the area of forensic pathology. This was a study led by E.T.L. Dror and his colleagues, including 4 forensic pathologists. And E.T.L. Dror, Jeff Kukuka, and a number of other scholars have been very influential in the idea of forensic science bias and decision-making outside of forensic mental health evaluations in more of the forensic science realm. And they've looked at a lot of different studies that have looked at relevance of data and biased decision-making in the forensic sciences. In this particular 2021 study, they did an experimental study with forensic pathologists out in the community. And all the forensic pathologists got the same profile about a child. They were basically asked to look at the findings for a 3.5-year-old child that had been found unresponsive and all had the same kind of injuries that involved skull fractures, a hemorrhage, also occipital contusion. And they were asked whether or not they had impressions based on the results of if there was a cause of death that they could determine based on the injuries that they saw of this child. Whether, in particular, they were asked to look at, or they were asked to determine cause of death. And so the big things looking at here was this an accident or was this a homicide? Now, half of the forensic pathologists were told that this was a white child that was brought to the ER by their grandma. Half of the forensic pathologists were told that this child was a Black child brought in by the boyfriend of the mother. So now, again, I want to emphasize here, the actual medical results exactly the same for all live practicing forensic pathologists. The only thing that differed, that the information that the forensic pathologists had, was the race of the child and the relationship of the person that brought that child into the ER. And what you can see here is in the scenario where forensic pathologists were under the impression that this was a Black child that was brought in by the mom's boyfriend, we saw a far higher rate of looking at those same results and interpreting them as being a homicide as opposed to an accident. There was a lot of outcry by the forensic pathology organization, particularly named the National Academy of Medical Examiners. They went as far as to, they were talking on different message boards as Dr. Kakuka informed me. They went to the journal, demanded that the editor release the reviewers' identities because they were convinced that the authors had rigged the peer review process. They filed ethical complaints against E.T.L. Dror and also the institution that IRB approved the study. They tried to have the 4 pathologist co-authors blackballed from the National Academy of Medical Examiners. They tried to have the study retracted. They accused the authors of data fraud, which involved independent statisticians coming in to try to redo the analyses. And ultimately, if you go to the 2021 Journal of Forensic Sciences, where this study is in, you will see several different articles that are responses to this study. Ultimately, there is response after response after response. They allowed forensic examiners to write their own responses and then the authors to respond to them in return. Now, what the authors were trying to emphasize here is they were not focusing on a specific question about whether race impacts decisions or whether relationships to victims impacted decisions. What they wanted to examine was that if you provided different background information to forensic scientists that were looking at the exact same medical data, would their impressions change? The idea here was, again, less about the specific data that they provided, but the notion that knowing the race of the child should not change your analysis of the actual medical results and seeing if it was a homicide or an accident. Knowing the relationship of the victim, these should all be considered ultimately irrelevant data for the specific question that pathologists were being asked. But it seemed to nonetheless highly influence their impressions of the case. The argument from forensic pathologists were, if we look at base rates, well, more children, more Black children die by homicide than white children, and that is relevant base rate data. What the researchers are arguing here is that those base rates are not relevant to your individual analysis of a specific case. And so this really highlighted the potential impact of contextual information that you have early influencing your impressions and your findings. What we're ultimately talking about in bias here is sway for data that goes beyond the influence that it should have. This could be whether the information is properly relevant, whether it is important, or whether it is accurate. And all that will impact whether we consider this data to be biasing. We all obviously want to be as unbiased as possible, but we have a lot of disagreement in the forensic psychology field and variability, even when we look at the same case. The fact that you're asked for a second opinion implies that there could be different interpretations for an evaluation. Why could there be different interpretations? Well, and why could there be bias? Well, forensic psychologists, forensic pathologists, we're all human. Humans are biased. We are subjective individuals, subjective creatures who have our own biases that we bring to the table and see things through our professional and personal lenses. We get in different information, and different information could be particularly relevant, informative, or even biasing. And so sometimes if you and I did the same evaluation, but we differed, it could be because I got certain info that you didn't, or that you had different records that I didn't have access to. That could all contribute to disagreement. But we also have decisions about what we're going to look at, or even what we're going to pursue. Collateral contacts. You and I both might know that the same person we're evaluating has a mother that's involved in their life. But we might differ whether we decide to try to call that mother and get collateral information from them. So we look at different info. But we also interpret info differently. So there are all these different areas, even when we get into, before we even get into the conclusions of disagreement, where there's so many steps along the way as human nature of doing an evaluation where we can disagree in the information we get, how we look at it, and how we interpret it. We're supposed to be impartial, though, and we know that we are striving to do this, but our specialty guidelines in forensic practice tell us that also, we try to avoid inaccurate evidence that might mislead finders of fact. This has implications for relevance of data, trying to not portray a picture of evidence that is actually irrelevant to the ultimate psycholegal issue at hand. We're supposed to provide info that is most relevant to the psycholegal issue. There's an obstacle with this if we haven't established what is the relevant information for a psycholegal issue. We're supposed to use assessment procedures that are appropriate in light of the research or the evidence of their usefulness and proper application. So again, we are considering what is relevant not just for a forensic evaluation, but specifically for the psycholegal question in front of us. What's relevant in one evaluation might not be relevant in another evaluation. Now, across mental health evaluations in the forensic context, largely, we have some common threads in the kinds of things that we're assessing. There are certainly exceptions to the rule for particular psycholegal questions, but generally, across the variety of criminal and civil domains that we assess, we're tending to look at functional abilities in some form as well as capacity. So the idea, the difference there of, what is somebody able to do presently versus what are they capable of doing, perhaps with other resources or down the road. We often look at knowledge bases. The scope of that knowledge, the focus of that knowledge will differ across different questions. And we also examine belief systems, what people think, how they perceive information. Sometimes that might focus more on a psychopathology perspective. Sometimes it may focus specifically on civil needs or specifically legal issues. We also, in forensic evaluations, tend to have a common thread of directly talking to examinees. We usually have a person or a group of people that are the focus of an evaluation, and we tend to directly talk to that person. And then we try to corroborate whatever information we get from that person with other data, other information that is available to us. What is relevant in one evaluation may differ for another one. Usually with records, we're looking for records of that involve people that have directly observed the examinee in a relevant context or at a relevant event. Relevant context could be if we are focusing, if a mental health history is very important to your forensic evaluation, having records from a psychiatrist that has seen that person before is somebody that has directly observed the examinee in a mental health perspective. That could be quite relevant to your evaluation. In contrast, if teaching observations from a 10th grade teacher, that could be irrelevant when we're talking about early disability evaluations or when there's a cognitive issue. But if we're focused on mental health for a 40-year-old that's being evaluated for a mental health evaluation, whether they're eligible for mental health court, for example, grade 10 teacher records might not be relevant for that evaluation. You're going to have to ultimately get at what is the psycholegal question when thinking about what is relevant to your evaluation. What is going to help you understand and address the psycholegal question? Broadly, we look at functional abilities and capabilities, but the type of abilities we look at are going to vary across the different evaluations that we do. The different types of knowledge that the examinee needs to understand can vary across the evaluations that we do. And the issues that are relevant to the beliefs also vary. So are we thinking in the present versus the person's recollection of things in the past? Are we talking about the ability to memorize things versus the ability to make a voluntary decision versus the ability at the time of an offense to understand what was going on at a different time? These are all, we need to think about what we're being asked to do and what abilities, knowledge, and beliefs will help us answer that question. Now, to potentially highlight the variability here, I'd like for us to think about different relevant information in different psycholegal questions. So Alex, this is where we'll have people, if you want to participate in this brief little exercise here, you can go to menti.com. There's the code. Alex is also entering this website and code in the chat box so that you can access the questions that we are about to to go over here. So it's just 4 different psycholegal questions, and I'd just like to get your poll, just a little poll here on what data you consider relevant. So for a competency to proceed evaluation, think about what jumps to mind when you think about relevant data sources. All right, so we've got the ball rolling now. Prior evaluations could be relevant to your to informing you on somebody's competency to proceed presently. All right, we've got a lot of responses now. Let me see if I can set this up in a way. Looks like the insight summary stalled out on mine a bit. But I'm seeing issues related to mental health history, mental health records, IQ testing, talking directly to the attorneys, mental status examination. So here's the difference here. Some people are talking about mental health records, which are in the past, versus data about the current, a current more structured approach to understanding their current mental health functioning. So we see different perspectives here on relevance of front information versus past information, as well as prior discussions with attorneys, with law enforcement. Okay. Next question. What about for a civil disability evaluation? Somebody has a lawsuit. The lawsuit for psychological or cognitive damages, and you're doing an evaluation of whether they have civil disability. What might be some data sources that are relevant in this situation? Oh, it did not switch. Okay, thank you. It does look like on my end that it is saying there is an unstable connection on this part here. Let me see. All right. So it doesn't seem like that part is going to work, unfortunately. Um, so I'm going to stop the share now. Sorry that didn't work further. What I want the following questions were about thinking about relevant data for a civil disability evaluation, for for a criminal responsibility evaluation, and for a parental capacity evaluation. And the highlight here is for us to be thinking about the idea, again, that the information we get is not inherently going to be universal across different types of evaluations, and that there are certain types of data that could be quite relevant to one evaluation and not relevant to another one. Law enforcement records might not be as relevant to prior ones to a competency evaluation versus a criminal responsibility evaluation. Jail observations, of course, are not going to be as relevant to one where jail is not a relevant issue to that discussion. But this gets back to the educational records example. Could educational records be irrelevant if there is no cognitive issue, but could they also affect your impressions of the person in a way that could be unfair or biasing? And that's the ultimate issue here, is that the consideration of, we could think of this as a no harm done if we look at irrelevant info, but it's not always no harm done. Oftentimes, the information, if it is actually influencing our impressions, can be unfair to be looking at if it gives us undue weight on our impressions. So going back to this general discussion of bias issues. Irrelevant information is particularly problematic for us the earlier it comes in an evaluation. And this is where the forensic pathology example comes in to play here. They were provided this contextual information at the same time that they were being asked to do their impression. So it was something that they got at the very beginning before they had even looked at the medical examination records, as contextual information. This is a death from a child who was brought into the hospital by the mom's boyfriend or by the grandma. So they had this information before they're even looking at the records. The anchoring effect is this process where the early information that we get starts to calibrate our expectations for what we're going to see for the rest of the evaluation. It tends to slightly skew us of where we think the evaluation is headed. You might have gotten referral information that you can jump to where the referral information had you suspecting that you were going to conclude one thing or the other before you had even seen the person you were going to evaluate. That information has anchored you. Now, some of that information could be accurate and reasonable, but the idea here is that if irrelevant information is some of the first things that we're seeing, that can calibrate us in potentially an inaccurate way, which then is exacerbated by confirmation bias. Confirmation bias is our tendency to look for things that support what we already believe. So if you get irrelevant information that is skewing your opinion, we then tend to look for information that supports what we suspect is going to be the case. If we go into an evaluation with context that we imagine that the person is probably malingering, we're going to look at things from a skeptical eye from a get-go, even more so than we usually do, and might ask questions or look at things in a way that more leans toward feigning or malingering than we typically would. And so that would be an example here of early information starting to skew what you look for or how you look at different information. And if you've ever worked with an examinee where you seemed a little bit more skeptical of them at the get-go based on their past information that they had feigned or malingered in the past, that could be an example of confirmation bias there, that you're already expecting it based on the prior information you heard. Now, malingering could be relevant to your evaluation, but the question is, how relevant is it to the psycholegal question that you're being asked in the moment? Why does this happen? Well, as humans, we tend to ignore or downplay evidence that doesn't support our initial theories. So we always look for, we tend to look more for matches than for disagreements. And so if you get early information that suggests severe cognitive disability, but there's other information that suggests they had no history of special education services or cognitive diagnoses as a child, you might be more motivated to downplay that of, they might have missed it, or I don't have all the records, and just more easily downplaying that information than you would have if you didn't have that other information beforehand. We also tend to exaggerate the evidence that we then see as supporting what we already want. So if we see something that supports our preconceived notions, we tend to overestimate how strong that evidence itself is because it supports what we believe. And then when things are a little bit more ambiguous, we tend to err on the side of it supporting what we saw. Testing results in the indeterminate range are more likely if you have no reason to believe. If we're using feigning as an example, let's say we have CEUs data that is in the indeterminate range, and you have prior data that suggests genuine responding in a number of different circumstances versus you were given other information that suggests a history of feigning. Depending on your expectations there, you might interpret that same score as evidence toward honest responding versus evidence toward feigning. Now, one thing we need to consider when we're thinking about, all right, I certainly don't want to look at irrelevant information. This is perhaps less of an issue of whether to look at something versus when to look at it. As we saw with the initial survey, there can be a tension here where we find things that are very relevant, but could also be very biasing to us. So that first opinion, as an example, is like, well, when do I look at that then? It can be very relevant to me, but could also be very biasing. This is where E.T.L. Dror and colleagues in forensic science come back into play. Adele Quigley-McBride has been talking about linear sequential unmasking as applied to forensic mental health evaluations as well. But the principles of linear sequential unmasking expanded would suggest thinking about what kinds of information in your evaluation is relevant to you, what could be biasing, and what is more objective. And if you have those tensions, it's harder to differentiate, but generally their recommendations are you look at the most relevant stuff at the beginning of your evaluation, and you save the irrelevant stuff or the unlikely to be relevant stuff for later in your evaluation. Now there's tension here because on the flip side, the idea here is that the least biasing stuff should be the first things you look at, and the most biasing stuff should be the stuff that you look at later. Again, this gets to the idea of anchoring and confirmation bias is the later you look at something, if proper safeguards are there, the less potent it might be to shaping your findings. Now, in terms of task relevance, we do have some data in the forensic science field about irrelevant information shaping findings. I've talked about the forensic pathology study already. But similar to forensic psychology, forensic sciences have their own guidelines, and they're also told they should only focus on task relevant information. They should avoid task irrelevant information that could bias them. And we see in different studies with forensic science examiners, the way that irrelevant information or biasing information can affect judgment. So I've already talked about the pathology example. Here we had a fingerprint analysis study where forensic scientists were looking at fingerprint evidence from a case. They were going to compare that fingerprint evidence to the fingerprint of the suspect, and they're asked to evaluate, is this a match? Now in this study, the different examiners were given different contextual information about this is the fingerprint of our suspect. They've confessed to the crime. Here's the fingerprint at the scene. Is it a match? Other people will told this is our suspect, but they do have an alibi. We want to see if these match. Now, if they were given that contextual information, 2/3 of the examiners changed their impressions, despite the fact that a confession or an alibi should not actually affect and is irrelevant to the physical analysis of do these fingerprints match. It should not affect that actual visual analysis, but it did. And we see these trends in a number of different forensic sciences, even for things that are often perceived as holier than thou, like DNA evidence. We've seen in particular, when you look at mixture analyses of multiple DNA samples, that there's disagreement in forensic psychologists if they were given other contextual information. They're more inclined to see the match if they are given contextual information that would suggest that they have somebody that is potentially guilty of the crime. So even with something that is looked at as quote unquote objective like DNA evidence, we can see how giving people biasing information or irrelevant information to the task at hand can ultimately bleed into judgments and shape conclusions. Now, how might this impact outcomes in the legal system? Well, we do know in forensic evaluations that we tend to be fairly persuasive if there is no competing evaluation. Judges tend to defer to our expert opinions. Juries tend to as well, unless there are other issues that come in at play. And in this study by Jeff Kukuka and his colleagues, they had prospective jurors read expert testimony, and then they had done a forensic science examination, and the jurors read testimony where on cross-examination, it was brought up that the forensic scientist knew that the suspect had confessed. And in cross-examination, they were asked whether knowing that confession could have impacted their judgment in the evaluation. In the study, they changed how the expert responded to that question. So for some experts, they acknowledged, yes, I knew about the confession, and yes, that could have impacted how I saw the evidence. When that happened, jurors took that to heart and discounted that testimony as being airtight fact. But as simple as the judge going, yeah, I knew about the confession, but as the expert saying, I knew about the confession, but it didn't change my opinion. Jurors believe that. So somebody saying, this didn't bias me was good enough for jurors. And so this really couldn't, our understanding of bias as scientists and professionals can then bleed into the influence that we have on legal decision makers. But again, here, the later irrelevant information is presented, the weaker its potential potency if we have proper safeguards. So all that to say, if we have certain irrelevant information or certain information that ultimately proves irrelevant, the later it comes up in our evaluation, the greater potential it is for us to be able to weed that out and have it less influential on our evaluations and our clinical opinions. This is rooted in linear sequential and masking. So some of the examples have been if you provide forensic scientists with the confession after they've already done their fingerprint analysis or after they've already done their scientific examination, it can still sway, but is less likely to sway than if they were given that information at the beginning as they did their analyses. Now, what is task relevant here? We're thinking about data that can contribute to accurate conclusions. Data might be irrelevant when it doesn't help us answer our legal question, when it doesn't help us answer the issues that help us address the legal question along the way. So an example here is information related to psychopathology. If the law for criminal responsibility says as a result of a mental disease or defect, well, you need to be able to answer, does this person have a mental disease or defect under the law? Understanding somebody's psych history might not directly help you understand whether the person was criminally responsible at the time, but it may help you with the prong of understanding first and foremost, do they have a mental disease or defect under the law? At that point, it becomes relevant. But data can be irrelevant if it is informative from a clinical perspective, but one that compromises your analysis of the actual relevant legal question. I'm going to breeze past this Garner study for the sake of time, but what I wanted to get at, this is one of the few surveys out there about what is relevant or not in evaluations. And they evaluated forensic scientists and gave them a bunch of info about, hey, this is info that you might get for an examination. Is it relevant? Is it essential? Is it relevant? Would you look at it or not? And what they saw was that for forensic biologists and other pattern evidence and forensic chemists, they had a general consensus on several different issues where they tended to see demographic information as irrelevant, which is good. They saw more disagreement, however, when you got to crime scene investigators, where you can see people with crime scene investigators had a higher rate of saying, knowing the victim's race or ethnicity was relevant, or knowing the name of the investigating officer was essential. I am not a crime scene investigator, so I'm not quite sure how knowing the name of the investigating officer would be essential to doing an investigation of crime scene analysis. But all this to say, there was very different perspectives across different forensic science practices in terms of what is actually relevant for their evaluations. It might be And I would argue it is indeed easier for forensic scientists to come up with consensus for what is relevant for their evaluations than it will be for us as forensic mental health evaluators. We have more degrees of freedom in most of our evaluations. They are less clear cut of this is the one thing that you look at, answer this question. We're given a question, and then we have a lot of discretion in terms of how to answer that question. So we have very limited data overall on what is relevant in different forensic psychological evaluations. We don't have the same kind of survey data that they have in forensic sciences. I'd love to see that. We at University of New Mexico would love to be part of those kinds of investigations. At the moment, we don't really have many of them. We have seen that as forensic psychologists, we do tend to vary on what we deem relevant to evaluations at large in terms of to test or not to test. Whether psychological testing data is relevant to our evaluation or not, given that we have wide variability on what we do in different evaluations. Now, one area where we have a little bit of task relevant data, and this is very limited, and with the full disclosure, this is not peer reviewed yet. This is an ongoing study with one of my back in the day undergrads who is now a forensic psychology doctoral student, Dominique Harris. I also did this study with Jen Perillo, Nancy Panza, police psychologist, and Lindsay Stahl, who is also a new doctoral student as well. We surveyed police psychologists on the relevance of asking about issues related to race and racism in police suitability. In New Mexico, our law for law enforcement suitability says we must assess any aspect of development we deem important to address suitability. And so we surveyed psychologists on what they do, but we also surveyed them on what they think is relevant. And we asked them about a number of different things. And there seemed to be a consensus that asking prospective law enforcement officers on their lifetime exposure, experience of people of different races than them was quite relevant in understanding their psychological suitability of making everyday decisions about people of different races. Also considered that if they had ever been part of a group that was known for racist behavior, that was also quite relevant information to have. Where there was less consensus was on information that we could characterize as potentially impacted by media consumption or about very specific cases or very specific contexts. So there was a lot of disagreement among the police psychologists on whether asking about specific cases of racist behavior by police officers or aggression by officers against people of different races, of whether commentary or opinions on those cases were relevant to ask in a suitability evaluation. Also, a lot of disagreement about whether or not views on different movements like the Black Lives Matter movement was relevant to suitability. So we have different areas here where there was a large consensus of this is important to address in terms of suitability, but what specific questions are relevant, we did not have a consensus on at all. Now, again, we don't have a consensus on what is relevant in a number of different forensic mental health evaluations. And what I want to wrap up here is looking at all the obstacles we have in achieving that. So we do a number of different types of evaluations. Again, as I referenced, there is a lot of degrees of freedom in our evaluations. It's not looking at a fingerprint and saying if it is a match. There is not a clear instruction in most forensic evaluations of you ask this question, you look at this information, and you make this interpretation. It's more general of this is the question we're asking, and you use the methods that you deem relevant and important to answer that question. So we all have variability of how we approach different types of forensic evaluations. We really need to think about what are the most relevant and necessary questions to answer to inform the psycholegal question. This can differ across a number of different evaluations. Some evaluations are going to focus more on pathology and psychological factors. Some criminogenic factors, details about the offense, might be more relevant in some cases than in others. Details of the index offense that the person's been arrested for might be quite relevant for a risk assessment, might not be as relevant for restoration of competency, in terms of like the level of detail that we're looking at. Psychological testing. In some states, certain tests are required. So you do with that what you will. You have to do the testing in that case. But we all determine whether testing or testing results are relevant to our evaluation. Timeframes can also really differ. If you look at competency, in particular, functioning in the present is what would be considered most relevant. In a criminal responsibility evaluation, functioning at the time of the alleged offense is much more relevant. So the scope of the time frame that we're looking at and the reliance on collateral data is also going to differ depending on the psycholegal question, how much we need to focus on self-account versus what that data is going to inform us on. Who decides what's relevant in a forensic evaluation? So do we do these kinds of surveys like they've done in forensic science and look at what the consensus is? We as a field could be wrong. We could all agree and ultimately agree on some fairly irrelevant things that could bias us. Do we select, as Dan Murray often uses the phrase, blue ribbon panel? Do we just look at some experts in forensic mental health and get a consensus from them on what are the best practices and then recommend that for what is relevant or not to particular evaluations? Do we use empirical data? Do we analyze reports? Do we look at biasing effects to help inform decisions of what we think is relevant or not? Or do we just leave it up to you? Do we look at the idea that these have natural degrees of freedom, these evaluations, and leave it up to evaluators to give their best practice to address the question, knowing that each case is different, each context is different, and the logistics are different for each individual case? Now, one particular challenging thing in terms of looking at what's relevant or not, let's say you have a file that says your state's behavioral health center records. What's in those records? Well, they might have psychiatric diagnoses. They might have info on the person's psychiatric history, might have the person's sexual history. I know I've looked at records for a competency evaluation and from behavioral health centers, and then all of a sudden it's page upon page about STD results. You don't know oftentimes from the description purely what's actually going to be in there and what's not. And sometimes there's information in there that is relevant in certain contexts, but certain traumas might not be relevant to a different type of evaluation. And what further complicates this is that once we look at it, we can't really unring the bell. We as humans tend to overestimate how much we can tune out info that we've already heard. So I make a decision whether to look at the data or not, but once I look at it, it's in here. And I can ultimately determine, oh, that info is spicy or juicy, but it's irrelevant to my evaluation. I can't just block it out. I can try to, I'm going to fail. The question is, how much does it influence my evaluation? We also have practical restraints in our evaluations. So the information that you deem relevant, you're going to ask for, well, what if the examinee doesn't want to share it with you? Also, how many of us have ever had control of actually when records come? I would love it if when I wanted records, they actually showed up on my table. But oftentimes we have to deal with the order of what we look at things based on what is actually available to us at the time. Who knows if when I try to call the mom, if she's going to pick up the first time? Do I stop after one time? Do I give it another go the next day? How many times do I call before I just give up? We only have so much control over what information we get. And so from a practical perspective, to do our reports fairly and efficiently, sometimes we have to look at information as it comes along. Now, circling back to that initial question about the first opinion evaluation, thinking about whether to look at other forensic evaluations when you're doing your opinion. Well, they could be relevant. So one thing we can think about here is not just if the report of a prior evaluation is relevant, but what about it or what from it is relevant? Well, knowing the consistency of how someone's presented from one time to another could be quite relevant to your evaluation. Knowing if prior tests have already been conducted and what the results are there could be quite relevant to answering your approach, whether you're going to do those tests again, or whether or not you want to forego those in light of other tests that you wanted to do. Knowing what records the other evaluator had might open your eyes to records you didn't know existed, or other sources that you didn't know existed, or that, hey, you weren't able to get a hold of mom, but the other evaluator was. They might have some quite relevant information for you. But you also need to consider the scope of the prior evaluations. So if you're doing a competency evaluation, a prior competency evaluation is probably more about relevant to you than a prior risk assessment. But a prior competency evaluation for your current case is even more relevant than a prior competency evaluation for a past case, given that there might be differences in the case details that could be relevant to decision-making in working with their lawyer. So the scope of time as well as the info can be different. But parts of that evaluation can also be highly subjective and biasing. So we need to think about the idea that there might be data from prior records that can help us and be relevant, but the impressions of those by the evaluator is where we get into more of the subjectivity that can skew us. So it might be less relevant to me how the actual past evaluator interpreted the data, but focusing more on what did they actually observe? What information did they actually have at the time? That info is probably more relevant to my evaluation than that evaluator's interpretations of it. It is my duty as an evaluator to interpret in the present time. So as a take home there, prior data might be relevant. The opinions might be less so and can color our expectations and interpretations. We have to constantly weigh the evidence that we have available to us of what is relevant versus what is also subjective and likely biasing. The idea here is that it's not about whether or not we look at information or not, perhaps as much as it is when we should look at information. And then as Jeff Kakuka and the forensic pathology bias experts have talked to me about too, one thing that they recommend in general practice is also being clear in your reports about the basis for your decisions in terms of if your opinions evolved over time and being transparent about your processes. We want to think about when we look at information, how we look at it, and then also acknowledge how it can affect us. So that is the content that I have for you. I will leave this QR code up for you, and I will throw it to Cassie for any questions at this moment.
Thank you so much, Dr. Perillo. Such interesting information, and I love this topic, and I feel like it's one that can be spoken about for a long time. Already some really good questions in the chat. I'm going to start with a strategy question here. Someone asked, would you make a note of information you reviewed but felt irrelevant? And what about information you are aware of but did not look at because of irrelevance, etc.?
I think we have a responsibility anytime we are answering a question for the courts or otherwise to be as transparent about the data that we received as possible. So noting all the sources of information, regardless of what I think influenced my opinion, noting all the data points that I did use in my evaluation, I think is critical. So in terms of if I looked at a record, whether or not I found it relevant or not, I'm documenting that in my report in terms of clear disclosure of all the information that came to me. So regardless of what my own view is of what influenced me, letting everybody know this is the info I had. So typically in that case, I would ultimately, if I didn't review it, if I might still, one consideration here in terms of documenting it is whether or not the acknowledgement that records exist is also informative. So as an example here, if I was given access to psychiatric records and for whatever reason I determined they were not going to be relevant, so I chose not to look at them, that is still data to me that the person has a psychiatric history in some form by the fact that I got psychiatric records. So in that situation there, where even the existence of a data point can give information, I would strongly consider disclosing that even if you didn't look at it, whilst acknowledging that you didn't look at it and why you chose not to look at it.
Thank you. This question pertains to kind of the last part that you spoke about there with prior competency evaluation. So just as a follow-up, based on your research, do you have recommendations for whether or not to read prior competency evaluations? And if so, when would you recommend reading those?
Well, I have I have a I have a safety net here in terms of the fellowship that we do here. Uh, and so for me, it's not necessarily whether to look at it or not, although the answer is I want to look at it in some form. Uh, the question is when and how to look at it. In the logistical setup we have here, where I always have forensic trainees, we are allowed to look for each other, so that way, if there is, we want to think about not just what I want to look at, but what I'm looking for. Why am I looking at that prior evaluation? Well, one thing that I want to look at is what has been done with that person and what information was available in the prior evaluation. In the way that we have this fellowship set up, because everything is through a training environment, my trainees and I, we can help each other out by looking at having the other person look at the records to document that info without me actually seeing the other evaluator's opinion. So I've done this for my trainees before, where they said like, oh, I don't want to be shaped by that opinion, but I want to know what tests they've done. I can look and say they've done this, 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 this. They had records for this, 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 this. And that way they got the information they wanted while not looking at the actual opinion. This is where we get into the weighing of what is balancing versus potentially biasing. The opinions of the expert could be a little bit more biasing relative to what tests have been done. So in an ideal world, I would want to look at that a little bit later in lieu of less biasing information. So I'm going to want to ultimately look at that opinion before I submit my report, so that I can also account for any kind of discrepancies of why we might have disagreed. But I can look at that actual evaluation later on after I've gotten the other information in terms of testing results or prior sources. I do my evaluation, I form my conclusions, and then I can look at that prior opinion at that point when the interpretations from that expert are less likely to sway my evaluation. And if maybe it does sway me for the better, where I need to consider this is a data point for them. Why do they think this? Well, one reason could be that they had different information than me. They could be interpreting things different from me, and just exploring why there might be some disagreements.
You have time for one more question here?
Yes.
Okay. Demographic question. Is it realistic to expect that demographics be left out of evaluations more often than not, unless it was absolutely relevant? Evaluator bias could still occur if they met for the interview based on the person's demographics.
It's not practical in a lot of ways. One thing that jumps out, even if you had no access to records, is our own heuristics in terms of gender, just purely by the name of the person that we're going to evaluate. You get assigned a case, you get a referral, you're going to get a name. So you're already going to have some gendered expectancies for a lot of cases there. For records, again, this is a thing where we can't unring the bell, where we're going to look at records that are going to have demographic information. It is impossible for us to to close our ears and eyes from irrelevant information. The idea here is for us to be mindful of how that information can impact our judgments so that we can put any safeguards that we deem appropriate or necessary in place. Does that eliminate the idea that that could affect our bias? No. Does it improve the odds that we can address it or minimize the impact it has on us? Yes.
Thank you so much, Dr. Perillo, for this excellent information once again. That wraps up this week's Law and Mental Health series. Next week, we'll have Dr. Lenore Walker to discuss APA professional practice guidelines for working with trauma survivors in clinical and forensic settings. We hope to see you then for another great discussion of issues of behavioral health and the law. Until next time.